We're live.
Okay, good morning. We're back at Senate Judiciary, and we're looking at H 230 and act relating to implementing mechanisms to reduce suicide. And basically, recommendations regarding firearms. Eric Patrick is the draft person who is on these discussions and knowledgeable of what's constitutional and what might not be, and has given us the advice that one of us, those that say it's constitutional or those that say it's unconstitutional, one of them is going to be right. But we don't know which one because the Supreme Court rulings in Braun have had to mess things up. However, I will say that we've had some wonderful testimony. Continue to get testimony on this bill. Many has taken it very seriously. Maybe if we could, Eric, start with the findings. If we could start with the findings.
Yeah.
Before we get to one suggestion I have for Eric is to add a section on severability. Given that we don't know what parts are constitutional and what parts may not be, depends on the United States Supreme Court. So if we do a severability section, it means that the whole bill doesn't go down because one section is found unconstitutional. So if we could go over the findings, which we really didn't do, we kind of skimmed over them during the walkthrough, and I think I looked at number five on line 16 of page 1. I just, because it's old, it really, I thought it is not necessary and could be removed. I think all the other findings on that page look okay to me, but you all may have a different view.
I guess my question would be, yes, but why exclude it? And looking at all the other findings I hear from Lorraine or whatever, it all deals with statistics and so on and so forth. So why would we move to delete number 5?
Why remove number 5?
Yeah.
Just because it's old. It's 2016 information.
Is there newer information?
I don't know if it's still accurate.
I haven't accessed it.
Might be 50% of the homes.
I feel like I have an email that
Okay,
addresses this. Let me see if I can find it.
all right.
I may not be able to because I have a lot of emails.
I also wondered about number 7. What, not necessarily arguing with it, but I'm not sure what it has to do with.
Yeah. Well, that's my quarrel with these kind of findings anyway, is they become a kind of essay at the beginning of
Well, if we're looking for suicide, ways to prevent suicide, and that's the purpose of the bill.
yeah.
I'm not sure how 7 helps make the argument.
Yeah, I mean, it may be true, but you're right, it doesn't advance why we need this bill.
And then,
I mean, I think, oh, sorry.
go ahead. No, if you
I
want.
was gonna say, you know, in regards to 7, you know, I mean, we're a very rural state and we have a lot of people living in rural areas. Yeah, I don't think that it's unrelated to point out that people who are at a greatest risk of suicide in Vermont include people living in rural areas, of which there are a lot. So I think that helps to highlight that point of it. I mean, maybe we could rephrase it a bit, but I think I see what the underlying purpose of that section is.
Okay. How would you rephrase it? Or you want
That
to take
part-
some time on that?
Yeah, maybe take some time on it. I'm not sure off the top of my head, but
I'm fine if you want to rephrase it.
So could I ask you that? So where did these all come from? It says the General
No
Assembly
idea.
fines. Where does this all come from?
The House Human Services Committee, I believe.
Correct.
So,
Yes,
So they
we'd
have-
have to ask them.
Mike, if you wanted to testify, we'll try to find some time. All right, at 10:30. Yeah, what? I don't know.
It was just, as Senator Bruce was saying, Senator North was asking where the findings came from. They were compiled by the House Health Committee and they have the supporting documentation up in their file. So
yes.
I didn't have any particular involvement with them, but that's where the source was.
One of the other items in 8 that I have a quarrel with is the last sentence on line 9. None of the respondents subject to extreme risk prevention order are known to have died by suicide. What,
Are known to have.
are known to have, doesn't, I think that should be struck,
Mhm.
unless there's an objection to that.
Yeah, it's not very factual. It's sort of like to the best of our knowledge, which
Yes.
So I have an email that cites the CDC's behavioral risk factor surveillance system from 2018 to 2020 that says the state rate of firearm ownership in Vermont is 44%. So we could update number
Okay.
5.
Right.
44?
Fine with
Yes.
that.
And I'm happy to send this to Eric.
That'd be great. Thank you.
Yeah.
And
I'm
do you
fine
want me
with
to send it to
updating.
Peggy as well to put it up on
Yeah.
our committee site?
Yeah.
What about the other part of it?
What other part?
It says 44% of Vermont homes and 32% of homes in the United States. Do they have that?
I'm sure they might on the larger website. It doesn't in this particular.
I think it's just how many Vermont
Yeah.
homes have firearms, what's more critical.
Yeah, this particular
compared to the rest
one
of the country.
looked at how many Vermont homes. It broke it down by county. It broke it down by age, gender, and veteran status.
If there's no objection, I'm fine with that. And if there's no objection, I'd like to take out the end of the extreme risk protection order, that none of the respondents subject to extreme risk protection orders are known to have died by suicide.
one thing I would point out, part of the findings section, at least as I understand it, is to create the foundation of why some of these policy provisions are necessary. And I think showing that, there were 18 FERPOs filed, conclusion, none of the people against whom they were filed died by suicide. And I think that shows the efficacy
But they're
of,
not sure. They are known.
And this argument, I think, points up the reason I've never really liked findings, because the House wants to put findings on every bill because they have lots of time and they want to put every bell and whistle that they can on. But when you get out on the floor, often you find yourself defending and arguing over the findings more than anything else,
Yeah.
because it is saying the legislature finds that. So people who take issue with any of these factual assertions, it just extends our the possibility for pushback exponentially. So, I see what they're doing here, which is they're trying to strengthen the suicide prevention piece from the get-go and fill it out with statistics. But I think it's not accidental that we're now quibbling over the different pieces.
Well, I just see that are known to. You could say we don't know. So that's why I just wanted to take that out. I just thought it was
And I hear that point. I'm just
Yeah,
bringing up why I
understand,
think
yeah.
they,
Number 11 is also, we just passed S4, deals with straw purchases. If you want to do that finding, it'd be better than S4.
How about, just my personal opinion, if we can't get anybody to come in and testify on the findings, the General Assembly finds as to the veracity of all the stuff here, we just eliminate the findings.
Well, we've
That's
done that
one
in more
choice.
than one
We've done that
case.
before.
Yeah.
That'd be my
Helps the
suggestion.
Conference Committee.
Yep.
my question, the thing that at first glance, the title of the bill, enact relating to implementing mechanisms to reduce suicide. I get that part, but there are also, if we're also talking about straw purchases, it's more expansive than just suicide. So, either we would want to take out 11 or
I wanna
take out
take
other
out
mention of,
I think we're dealing with straw purchases in S4.
Mhm.
If they wanted to put that in S4, I wouldn't necessarily object.
Mhm.
I just want to make sure we're consistent too, if this is a bill for suicide, then, I don't know why we would also then start diving into straw purchases unless we
That
change
that
the
would be the
title of the
same
bill.
thing with number 10.
Well, I think we've definitely heard some testimony, and this actually brings up one of the things I have been thinking about. We've heard some testimony that yes, this work would prevent suicide. It also would help prevent community violence. And so I wonder if changing the title of the bill to address that we are looking at mechanisms to reduce suicide and community violence.
I agree with that.
Good idea.
Me too. And Senator Sears and I had spoken about striking section 2, legislative purpose, because similarly, it narrows it and it says explicitly the only thing we're intending here is to impact suicide rates, whereas I think of it as a more broadly based effect from this bill. And, I don't think the legislative purpose section does anything really. But again, the House likes to divide up the jobs and they have one person or two people write the findings and somebody writes the intent section. So a lot of times we pull pieces off that are kind of a little over explanatory maybe.
We could add, on line 18, we could add, the purpose of this legislation is to prevent death by suicide and other violent crimes
Mhm.
by reducing access to.
Well, it's kind of, the Attorney General had a small amendment, and I'm not sure I'm correct on it. Eric has that in the purpose section. She said, after, on line 19, after access, to put in access by children and prohibited persons.
Mhm.
Right.
I remember that, but I don't know that I agree, especially if we're talking about a broader impact towards community violence. Like we're really, I just don't know if I agree with that
Well,
change.
let's do the purpose after we hear testimony. We've got a number of witnesses, but I did want to go over the findings. I have no objection to pulling them all out, quite frankly.
And then, as you say, if we get into conference, that's something that they could substantiate
That will be
and add back
no
in.
matter what we do. Because we've already. So I'm gonna go a little off schedule and ask Mike Ferrand, who is here as a citizen, to speak on page 230. And then we'll hear from Billy Clark, Rebecca Turner, and John Rogers.
Thank you very much, Senator Sears and committee. Mike Farad, Sergeant First Class, retired, U.S. Army. I'm a father of 2 teenagers. I'm a resident of Williamstown. I'm not going to speak today in my profession here. I'm speaking personally. I did submit written testimony last Thursday. I don't know if the committee would like me to recap that and read that or elaborate on some of the points in it or field questions. What is the?
I have a copy of your letter.
Okay.
We can get them to the rest of the committee, if we haven't already.
So I can summarize a little bit. So as a member of the Army Reserves, and it's important that to put that out there, that I was not part of the Vermont National Guard. I was a Vermont resident who was a member of the U.S. Army Reserves, and my unit was based in New Hampshire. I deployed 3 times to Iraq, Afghanistan, and then back to Iraq. After my last deployment in 2015, we got back in 2016. Approximately 2 months after we returned, a soldier from my platoon took his life. He shot himself with his hunting rifle in his bedroom at his parents' house in Berlin, Finland, about 10 miles from here. Because he wasn't a Vermont National Guard soldier, it doesn't get a lot of attention when reserve soldiers that are just residents of Vermont are affected. I think that goes unnoticed a lot of times, and not anyone's fault. Vermont's very proud of their Guard, and they should be. They're fantastic soldiers. But when somebody who's not part of the Vermont Guard, something happens to them, it's just a little bit less noticed. You probably didn't hear about what happened to him. That soldier was in a combat zone, an active combat zone. We were right between Ramadi and Fallujah, while ISIS controlled both those cities and the road in between them. Those cities are about as far away as Barrie and Montpelier. So we were where Berlin is, basically. And we were supporting the Iraqi army to get ready to overtake and reclaim those cities. So we saw combat action as part of that deployment, and we were on what's called red status with your weapon. So we M4 assault rifles. Red status means you have a magazine in the well at all times. There's a round in the chamber at all times, and the weapon's on safe, but it's within arm's reach. So you never let it go. You bring it to the porta potty with you everywhere. Sleep with it the whole 9 yards. A soldier, if he wanted to make an impulsive decision to end his life, he had every opportunity to do it there. He had 210 rounds in magazines on his person at all times. He didn't do anything until he got home with his hunting rifle that he owned. And so I think that's a fresh perspective of how these things can happen without being impulsive sometimes. There was a news story I saw today that is about research that was recently done between a bunch of universities and some folks from Vermont. And their findings show that 40 soldiers a day die by suicide. 40 veterans a day die by suicide. And I think it's important to realize that sometimes those are impulsive decisions and sometimes those are not. Sometimes those are service related and sometimes those are not. He was 20 and it devastated his family. And as his platoon sergeant, I looked out for his family. I helped them through the process. I supported them. We still gather at his grave for anniversaries, birthdays, and things like that. But it devastated them. When this bill was being reported on the House by Alyssa Black, I was sitting in the balcony like I do sometimes and listening. And her testimony, like you saw yesterday, is very powerful. It's very personal. It's very raw. And it struck me that she was reporting this bill. And I started thinking about that soldier. I started thinking about what used to be known as 22 a day, now 40 a day soldiers. And then I started thinking about my own family and my own son. I have a 16-year-old son, and he's impulsive. He doesn't think before he does a lot of things like a lot of teenagers do. It's how their brains are wired. And he's a good kid. He's such a good kid, and I love him so much. But he can drive you nuts sometimes. But I started thinking about him, and I started to think about my own rifle at home. So because of my military service, I did choose to have a firearm at home for self-defense. I find a lot of relaxation in going to the range and shooting. That's also a fun hobby that I enjoy. But I thought about how I secure it. And it's always been very informal. I keep it out of sight, but close by. I keep the ammunition close by. I don't lock it. I didn't lock it. I didn't know much about locks. I didn't know much about securing a weapon in that kind of way. The way I would secure weapons, take the bolt out, remove the firing pin, keep the ammunition separate, something like that. But I hadn't thought about locks. I found them in my own ignorance to be cumbersome and an obstacle to defending my home. But I'm sitting there and I'm listening to Alyssa Black. I'm thinking about my soldier's family and what that did to him. I'm thinking about my son, and I'm thinking about my AR-15 at home and what kind of example I'm setting. And so I said, I should at least do research and at least become educated on what these locks are these days. I heard. So I did some research. I like everyone else, whipped out my phone and started Googling and Amazon and this and that. And I found out that there is a biometric trigger mechanism, biometric lock, goes by your fingerprint. It locks the trigger in place to the trigger well, rendering the weapon useless, setting that it doesn't have that fingerprint. About $90, and it had a lot of good reviews. So I said, you know what, $90, that's worth a shot. That's not a lot of risk to take for my family's safety and for to avoid something like that. So I bought it. I just said, I'm just gonna buy it. What the heck, right? I can return it. It came 2 days later, and I checked it out and read the instructions and programmed both of my thumbprints into it, tested it. It works great. I tested it on my rifle, and I thought, how much delay is this going to cost me? And so I practiced unlocking it many times until I got so proficient. It takes me 3 seconds to have my AR-15 fully operational, ready to defend myself, and it's completely inoperable before that. So 3 seconds and $90. That's okay with me. That's okay with me. I accept that risk for my family's safety from themselves. That day, and this is, I don't believe it's coincidence, but that day, my son and his best friend were playing Xbox, and they always do. And they were talking trash. And the friend's mom sent me a text message, and she said, I know they always talk trash, and I get that, but this really bothers me. And she sent me a screenshot. And the screenshot was from her son's phone, and it was my son saying, go kill yourself. And I just stared at it, and it hit me. He's thinking like that. So I confronted him about it, and he said it first, and everyone says it, that's just what we do, and you don't understand, old man, and but he made it seem like that's the vernacular teenagers are using these days, instead of some of the things that we would say to our friends, ribbon them, go pound sand, go do this, go do that. It's go kill yourself. That's what they're saying as a joke. So I told my son about my soldier. I told my son about Alyssa Black's testimony, and I told him about what I did with the gun. And he said, Dad, I didn't mean it. I said, I don't care if you didn't mean it. Think about what you're saying. Think about the jokes you're saying. What if your best friend was contemplating that? What if he was on the edge and that was what pushed him over? I said, you'd never, ever be able to let yourself get over that. So we had a really good conversation. And he understands now, and I'm confident that he understands that. And I don't think he would ever hurt himself, but neither did a soldier. Neither did 40 veterans' families every day. Very rarely after a suicide does someone say, boy, I saw that coming. That's not very common. Most times you hear, I never saw that coming. With my soldier, no one saw that coming. It just happened. And so I'm going to protect myself, my family, and I'm going to protect them from intruders in my home and from themselves.
Very helpful that you could buy that thing for $90.
Mm-hmm.
That include tax.
Yeah. No, it was $89.99 before tax. It's okay. I'll eat that. That's all right. We all pay taxes, right?
Yeah, well, I'm on eBay a lot buying stuff for my wife that I can't buy locally. Mm-hmm. So, it includes tax, so they tax you automatically for Vermont. That's very helpful, Mike. Thank you. Are there questions for you?
Well, just a quick one. We talk either off camera or whatever. I'm interested in this device that you purchased.
I was about to,
I mean, is it, and I don't want to talk about, is it accessible for more weapons or just one $90 per?
It seems as though it is accessible. It works on multiple weapons. So it's about this big, maybe a little bit bigger than this. It's 2 parts. And so the lock breaks it in half. and then the lock, and then when you push it together, it locks into itself. And so if you think about, you have a trigger well, and then the trigger is in there, right? It binds to all of that to hold it all in place. And then when you put your thumbprint on it, it just falls apart. Just.
Could you send us that information or?
I can send you, or I can bring it in.
Well,
I'd like to
Yeah.
just get the information on it so I can look at it myself.
under
personally.
1830, that covers you, right? You don't have to put it in a locked.
No, it just has to
Or
be
you could do that.
disabled.
Yeah, you can just trigger the lock. You
Right.
don't have to have a safe.
And there are different locations that give away trigger locks for free,
Oh,
like the Howard Center.
Yeah, most of our mental health
the Howard Center
agencies.
does?
Yeah, we're trained in any crisis and suicide evaluation. If we deem someone to be a risk, the very first thing we do is ask about guns in the home and offers a safe storage for those weapons, whether that be a trigger lock or a lockbox. I personally keep my handgun in a biometric safe by my bed, and similarly, I can open that up in 5 seconds or less. But there's lots of advanced options out there that are not cumbersome, but also keep people safe. But that is the very first question, once we've gone through a suicide evaluation, is to ask whether or not there are firearms in the home, whether they're stored safely, and then we will give people.
Like that.
I wasn't aware of that.
And I'm glad to have that testimony for a lot of reasons, but one of the things that's always bothered me is with this debate, the idea that unless you have a fully loaded gun that you can roll over in bed and just grab and shoot, you're going to be incapable of self-defense. It is exactly the opposite in real life. The chances that someone in your home dies because that firearm is outloaded is exponentially greater from the risk inside the home than it is from an intruder. So, having a lock that you can get off in 3 seconds is going to cover you in any situation where someone breaks into your house. And it's also going to protect you from the greater risk that a child gets it or an intruder uses your weapon on you, et cetera.
I mean, by way, I was just gonna say by way of example, I have, it's not biometric, but the safe that I use, it's, you set a combination on it and it's silent. So it's the buttons that you press, there's rubber around them so that you're not making any noise. And within about 3 or 4 seconds as well, you press a couple of buttons, it opens completely quietly, and you're good to go if you need it.
Yeah.
The reliability of the device was a real concern of mine. I did a lot of research. I landed on something that I felt comfortable with. I would not get something cheap. I would not get something I wasn't confident in. And if it didn't work every single time I practiced it, I was going to throw it in the garbage.
If the biometrics don't work, you also have a physical key. Yeah.
If there's a physical key. And to your point, Senator Bruce, I mean, people live in very different situations. Some people are in apartment buildings, some people, I have plush carpeting. So it's, I mean, I used to joke with my son that you can't stomp up the stairs because it's just, so, it's a quiet place, but I have 2 really loud, sensitive dogs, and anytime a leaf blows outside the window, the whole house hears about it. So I'm confident that 3 seconds is not gonna be the downfall of my family in an intruder situation. I have a few other modifications to the weapon that would deter people before I even have to get to that point anyways, but it can be intimidating to have a red dot on your chest, for example,
Right.
something like that. But that was an acceptable risk. Other people might have different living situations, and so I wouldn't presume
Yeah,
that mine's.
I'm
the
just
same.
speaking to the
But
worst case scenario mentality.
Yeah.
So I remember when we were passing S55, there were a lot of talk about, gangs breaking into your house, and you would need enough firepower to take down 15 people, because what if the gang had 16 people? Or and the doomsday scenarios can always be created to justify the need for huge firepower at home. I'm just thinking in real life, often it's much less risky, and a gun with a trigger lock, I think, is plenty enough self-defense capacity.
Once again, and I had this conversation with Eric yesterday, to remind everybody that under this bill, it is only a crime if something awful happens, which is at least under the House. So the House version of the bill as it's presented to us, creates a situation where, similar to click it or ticket, where unless there's something happens, unless you've got something, somebody grabs the firearm and uses it, and there's not a criminal offense. So I just think we need to remind ourselves that it's really negligent storage of a firearm rather than requiring firearm storage, frankly.
Although there is a prohibition,
Well, there's prohibition in
Yeah.
there, but
which I think is important,
yeah, no, it's
but
fine.
it's not criminalized.
But it's not criminalized.
Yeah.
So, a person can be sued civilly.
Yeah.
But I just want to make sure people who are listening into this conversation is that the bill changed dramatically in the House from what House Human Services had in terms of safe storage to what Judiciary did.
I genuinely don't have an opinion about whether this should become law or not. I can see that I don't think it would have done anything differently for my soldier, but it may have done things differently with my son. To that point, Senator Sears, if a member of my family did something horrible and permanent, and then I had to face a fine or jail time after that. I don't know how that helps me, but
There is a piece of the bill that allows the prosecutor to take into account the emotional impact on.
yeah, if you were devastated by that, and then you found out that you're also facing a huge fine, thousands of dollars of fines and jail time, and you're trying to cope with a devastating loss like that.
Wow, you could also be facing civil
Yeah.
lawsuits as well.
I made my decision for.
Yeah. I thank you very much, Mike. We appreciate you taking the time. Our next witness is Billy Clark, litigation attorney with Gifford Law Center to prevent gun violence. I guess that's the full name of the Gifford Law Center.
Yeah.
Billy,
Thank you so much.
welcome.
Thank you, Senator. Thank you all for the
Let me
for the time this morning.
introduce I'd like to introduce the members of the committee. My name is Dick Sears. I represent Bennington County and the town of Wilmington, Londonderry, and those two in Wyndham County and everything in Bennington County. Senator Sheen.
Well, I'm Nader Hashim. I live in Dummerston, representing Wyndham County.
And I'm Phil Baruth. I represent Chittenden Central.
Bob Norris, Franklin District.
Tanya Vyhovsky, I also represent Chittenden Central.
Okay. We're pleased that you can join us on remotely, and please go ahead with your testimony.
Excellent. Well, thank you all so much for the time this morning and for the opportunity to be back in front of this committee again. So just to introduce myself again, my name is Billy Clark. I'm a litigation attorney with the Giffords Law Center, and under the leadership of former Congresswoman Gabrielle Giffords, Giffords Law Center researches, drafts, and defends the laws, policies, and programs proven to save lives from gun violence. I work remotely for Giffords from my home in Burlington, Vermont. I'm a licensed Vermont attorney who's been practicing in Vermont for how many years now? I guess 5-6 years now, getting there. Starting to build up a career. I previously worked in the litigation group at Downs Racklin Martin in Burlington, Vermont, where I litigated cases in state and federal court across Vermont. And before that, I served as a law clerk for a federal district court judge and then a federal appellate court judge in Boston. So I first and foremost, with the discussion of trigger locks this morning, I do want to plug a point that Dr. Bell made yesterday about the new Gun Safe Vermont program involving trigger locks and the ways that people can get free trigger locks. So there's a website for Gun Safe Vermont through the U.S. Attorney's Office webpage, and it lists in every county in Vermont the places that you can get these trigger locks for free. I don't believe it's the biometric versions, which obviously have their advantages. I think it's a little bit more basic, but You can get them, at public libraries. I know in Chittenden County, the Fletcher Free Library has them in stock. You can get it at the Essex Free Library out in Essex Junction. So there's every county has them available. And so I would, regardless of what we do with our testimony today, that's just something I want to make sure that I plug from the forefront.
I'll be right back.
So Representative Black told us some of the many unreported stories of Vermonters dying by suicide from firearms yesterday in very powerful testimony. We heard another piece of powerful testimony of the impact this has had on Vermonters. I wanted to do one other story that of another Vermont family that has sort of slipped through the cracks, and it's the story of the Wynn family from Randolph, Vermont. It was a family of four. Michael Wynn is the father. Bridget, his wife, and they had two children, an 11-year-old son and a baby about 10 months old. Mr. Wynn bought a farm in Randolph, Vermont, and tried to make a living on it. He had just come to the United States from Ireland and tried to get a small farm going and was having a rough go of it and started to become really despondent and frustrated. He sought out medical help from a doctor who tried to give him some medication to treat him. It did not work. And he was speaking with his wife one week and said, I wish that we were all dead and we were just out of our trouble. Then on a Friday, he'd never owned a gun before. On a Friday, he went down into town in Randolph and purchased a cheap pistol. He told the person he was buying it from that he wanted to shoot squirrels in his that had been giving him trouble with his crops. So he buys this on a Friday, and then Saturday morning at 4 a.m., his wife wakes up to hear a noise, and he's shot their baby. Mr. Wynn has now walked down the hall and shoots his wife, and then chases the 11-year-old son out the door. The 11-year-old son escapes, notifies some neighbors. The neighbors try to find Mr. Wynn, and they find him eventually, sort of hiding off in some woods. And he he's shot himself. He passed over a railroad track and found a quiet place hidden in some bushes, and he shot himself. They tried to perform aid on him, but he had passed. His wife, who he had shot earlier that morning, was taken to a doctor for treatment, but she lived, I think, for another day or so, and then passed, succumbed to her wounds. But she made clear, so she knew that her husband had died at that point, and she made clear to the people around her that she wanted to be buried next to her husband, and that she wanted to be with him forever, to have the two graves be right next to each other. And this is what was reported. She said her husband never would have done what he did had he not been crazy, for he was always kind, and they never had a word of trouble. So she was buried next to him in a small grave in Randolph. This was August 7th of 1878. It was well reported in newspapers throughout Vermont. The account I just gave from it came from the Green Mountain Freeman, but it was also reported in the Free Press and a couple of other newspapers that were back then. And I bring this story up not just for dramatic purposes, but to show this is a problem that's been recurring, and it's been accepted at times as just a natural part of the world. But the people who live these moments, they know that suicide is not a deliberate, intentional act done by someone who's thinking through things right. Mrs. Wynn, Bridget Wynn, knew that her husband was not right of mind when he made these actions and wanted to remain with him forever. And we see in this moment, two places where, had provisions like that are in H230 been in place, you could have seen a different outcome. This person sought out medical help. His wife, he told his wife that he wanted to kill everyone, that he wished they were all dead. And then he went out, bought a gun, and then less than 24 hours later, used it to murder his wife and kill himself. I think so often we can get, caught up in this notion that these tragedies are just tragedies and they're unavoidable and they're just the natural course of living in a society, but they're not. There are ways that we can put things in place, not to prevent all of them, but to give off ramps to have things that we can step in and do to make these less likely. Had there been a waiting period, would, Mr. Wynn have been able to, would he have rethought some of his decisions? Would his farm have had better success? Would he have been able to sell his farm? He was trying to sell the farm. Maybe an offer would have come in. Maybe his children wouldn't have been around when he finally got the gun. That there's just little off ramps that could change these tragedies in different ways. And that's what I believe H230 is trying to do. It's getting at, we're never going to solve all of these problems, but that doesn't mean that they're completely unaddressable. And I'm going to I'll follow up with the committee to send along these articles. I have PDFs of them and want to, I'm happy to include them as part of the record from the newspapers of the time. But to dive more into the details of the bills themselves, I want to start with the safe storage. And we heard a great discussion today of, how this safe storage bill as written is different from, the ban that was discussed, the ban on handguns in Heller, DCV Heller. You've just heard testimony about how these guns remain operable. They remain operable by the person who's supposed to be using them. If you use a trigger lock like that. I would also note, we've talked a lot about the penalty provisions of the bill and how it doesn't penalize certain things, but let's also look to the textual exception in the bill. I think this is a really important part of the bill that's been overlooked so far in the discussion. So it's at 4024A2, and let me just get the exact language out and I can tell you the page that it's on in the draft. So yeah, this is on page 4. So, you have 4024, which is the secure firearm storage. And then you got A1, which sets forth the prohibition. But then you have A2, which says the exception, which says this subsection shall not apply if the firearm is carried by or within such close proximity that it can be readily retrieved and used by the owner or another authorized user. And so, in that view, that what I believe that was trying to get at is if a person, really wants to, carry a weapon on them at all times in their house because they're so concerned about that, or frankly, if they want to put it on their bedside table next to them so it's within their immediate control, I believe that is exempting that part from the what is prohibited by the bill. So it's already getting at that, concern that we've heard invoked so many times of the intruder in the night. I mean, that's not as a part of the penalty part. That's part of the covered conduct, what's actually prohibited by the bill. So I also want to just go back. I don't want to focus on this too much, but I do want to rebut some of the testimony that was given yesterday by Mr. Davis from the Gun of Vermont organization, in particular, because some of it went to representations that I've made to this committee or that, others from some of the gun violence prevention groups have made to this committee. So first of all, and we've talked a good amount about this, Mr. Davis testified that, those who don't die on a first suicide attempt will simply try again later. And I think his exact words were, those who are not truly suicidal do not die. And that's not how suicide works. We've heard from Dr. Bell yesterday, suicide is an impulsive act. And I wanted just to add one other, data point. So this is from a study that's up on our website, and I'm happy to provide it to the committee. But, according to one study, 90% of suicide survivors do not go on to die by suicide. 90%. So again, it's about creating off ramps. If you use a method of suicide that is of making an attempt of suicide that is so lethal, like a firearm, then you don't give a chance for, another moment. But, for so many of those who survive a suicide attempt, they don't go on to die by suicide. They are able to get mental health treatment, or they find themselves out of crisis. That one moment does not come to define them in a way that, I think in this sort of archaic notion of, oh, it's someone making a conscious choice, controlling their life. It's not. It's an impulsive person responding to a mean message in a video game. I mean, it's anything. It's anything that could be leading someone to feel that. In particular, when we're dealing with teenagers and young adults. The other part that I want to go to, this is again getting more into the sort of legal questions. And I'm happy if this committee is interested to get into a longer discussion of the Bruin decision and the test that's used in evaluating these things. I'm happy to explain that. I want to kind of focus more on what seem to be the questions that the committee is getting at, right now. But I'm happy to discuss that more broadly to the extent the committee wants to. But Part of what Bruin focuses on is, the historical tradition of firearms regulation. If some sort of regulation implicates the plain text of the Second Amendment, then the government must show that it's supported by the historical tradition of firearms regulation. And Mr. Davis yesterday referred to the gunpowder storage laws that me and others have cited in the record as sort of disingenuous, I believe was his word, and that they were town ordinances that weren't binding laws, and that there are no binding laws from that time. And they were about large quantities of gunpowder that had no commercial. They were all commercial purposes and not for the home. And with respect, again, that's not accurate. And I would direct the committee. I'm happy to resubmit this to the committee, but to the House Judiciary Committee, I submitted several historical laws from Vermont that were laws. They were not just town ordinances. I submitted one town ordinance from the city of Rutland, but then there's several laws that I submitted. Now, I mean, to be overly technical, and I'm happy to have legislative counsel interject here, but they're laws in the sense that they are the legislator approving of changes to a municipal charter. So they appear in the Vermont Acts and Resolves, and they carry the weight of law, in my view. But that's, I guess, the technicality of some of it. And that we have an 1865 law, an 1865
It
amendment
would be
to
helpful if you would send those to the committee assistant, Peggy Delaney, and have them on our webpage. That would be helpful.
I'm happy to do that. Yeah, and it's I believe 5 laws in total. Again, ranging from Rutland to Montpelier to a bunch of the different cities from late the 1800s.
Whoever has to make the argument on the floor for some of this would probably benefit from those laws.
Excellent. Well, I'm happy to send those over right after this. I can definitely do that.
Okay, sounds good.
The one law that I really want to focus on, though, is the 1863 Vermont gunpowder law, because this was a law that applied across the state of Vermont. It regulated gunpowder storage throughout Vermont, and I want to get the exact numbers in front of me, but it does talk about prohibiting people from having 50 pounds of gunpowder in their home. But then it also talks about how one would store a smaller amount of gunpowder. And it creates an offense that if one has a quantity exceeding 1 pound of gunpowder, they would be in violation of the law unless the gunpowder is contained in a sound canister of tin or other metal. And this is a law that applied across the whole state. And unlike Mr. Davis, who claimed that these laws were not analogous to any modern gun regulations, the Vermont Supreme Court has actually held directly the opposite. In the State v. Mish decision, they cited the 1863 gunpowder law and held that was analogous to the large capacity magazine ban that was being challenged in that case. And the way that the Vermont Supreme Court found that it was analogous was that the court said that the gunpowder storage law, quote, placed a burden on the ability to rapidly prepare and fire multiple rounds of ammunition, which it found was analogous to the magazine limit here. And the court went on to say that this law, as well as a few other historical laws that were cited, show that even in Vermont, the use of firearms has long been understood to be subject to regulation by the state. So again, I just want to make clear that there is historical support for provisions like safe storage. There's throughout both Vermont and the rest of the country, there's plenty of laws that show that this is consistent with the historical tradition of firearms regulation. And perhaps more importantly, the way this bill is written, Senator Sears, as you've observed, it is not a ban on a specific requirement of safe storage in all contexts. I would include one other point. This is only coming into play for houses where there is a child or a prohibited person prohibited from possessing a gun. So we're talking about houses where there are children or convicted felons. I mean, I think that's sort of the key. There's going to be a few other folks, but I mean that's really what this is going to. This is a narrow bill in that way. It's not saying safe storage for everyone, everywhere, always. It's saying, this is how we're defining safe storage. We're only requiring it in these particular circumstances. You're allowed to do these sort of behaviors as well, and you're only going to be penalized in these circumstances. Oh, and there's all sorts of charging discretion that goes into that as well. So I want to switch over now to the waiting period, unless there's particular questions that the committee has about safe storage right now.
No, go ahead, please.
Okay, great. Well, so I know there's been some discussion about, why 72 hours? Why is that number picked? And I believe shortly before, perhaps just as this started, I think there were some written materials submitted from Giffords on behalf of this, which I can go over that provide some of the studies that show why a 72-hour period is going to be better than a shorter period. And really just in general, why a longer period is going to be better than a shorter waiting period for addressing a lot of the policy goals that H230 is going after. But I'll get into those, those studies in a moment. But what I will say, and I believe this was talked a little bit about yesterday, is that 72 hours is currently the lowest waiting period that any state has at any state level waiting period. And so, obviously there are states that don't have waiting periods, but for the states that do have waiting periods, 72 hours is the minimum. And the two states that have that are Illinois and Florida. And those waiting periods were signed into law by Republican governors. It was not a, controversial outlier views. These were, bipartisan, bills that were signed into law by Republican governors. And as this committee thinks through, concerns about constitutionality and things like that, I will say, as someone who defends these laws, there is a benefit for going with the minimum that others have done. And that, even if, for example, one was to adopt a 48-hour, requirement rather than a 72-hour, it would make it more challenging in court to rely on, those other laws, those 72-hour laws. In particular, when, I think there was some testimony about yesterday, when Governor Scott vetoed the 24-hour bill, there was a discussion of, well, there's not support for this. There is support, and there is a embrace of the 72 hours as the minimum amount that you would have for a waiting period. And so I think, in particular, in a land of some legal uncertainty, following the lead of other states is going to be an advantage. I've checked. I don't believe those laws have been explicitly challenged in court in a way that they've been upheld. I think there were some challenges that got kicked on some standing grounds and those sort of things. Regardless, part of what they talk about in Bruin is how the New York law was this, unprecedented outlier law. And so I think, to the extent that the H230 follows, the minimum that other states have established, that is to its benefit from a constitutional Bruin analysis. And Senator Sears, I did want to raise one question you had asked about yesterday, that some states have no waiting periods, even though they may have strong gun laws in other ways. I believe it's Massachusetts and New York.
And Connecticut, right?
Yes, and I don't have Connecticut in front of me, but I know for Massachusetts and New York, and I think this was perhaps mentioned yesterday, but both of those states have licensing requirements, that you have to obtain a license before you can make a purchase, of a handgun. And those licenses build in, a form of a waiting period, and that you have to get that approved. And I believe in New York, that can take upwards of up to 6 months. In Massachusetts, I think it's a 40 days before a denial or an approval has to be made.
Once you have the license, you're able to purchase immediately, right?
I believe that's correct. Yes, there's no other additional.
So there is no waiting period if you're already licensed to carry.
Yeah, and I believe this issue was discussed a bit in House Judiciary. Would there be a way to carve out, people who are buying for a second, who already own a gun? I will say, without a licensing system, I'm not exactly sure how one can meaningfully do that. And I'm certainly not going to try to pitch a licensing system right now when we have many other things on our plate. But that's the advantage of a licensing system, is that it allows for these, approvals to take place, and then, to have future purchases not be subject to the waiting period. But California, which also has they have a 10-day waiting period, and the systems they have in place, is another example of a state like that. But to go to sort of the studies, and I just want to pull up that material that was just submitted. yeah, studies suggest that waiting period laws are associated with a reduced rate of firearm suicides, and that they can reduce it by 7 to 11%, and that the majority of waiting periods that are currently on the books require waiting from about 7 to 10 days. But the research, has not gone into the granular level of 7 to 10 days versus like 3 days. But the general trend of the research shows that that longer waiting periods are generally are maybe more effective than shorter waiting periods. There was one comparison study that found that the longer a state's waiting period, the lower the firearm suicide rate and the proportion of suicides resulting from firearms. So it shows a positive correlation with the longer a waiting period, the more effective it's going to be. So that's, really because, for the primary reason from a constitutional point, I would say going lower than 3 days, it makes it harder to invoke some of the same reasoning that supported, the Florida and Illinois laws. And that, anytime you're, being an outlier in this area, in particular in the post-Bruin world, it does make it a little bit more of a challenge to defend. So that is why I would advocate for, at a minimum, a 72-hour period. I think there are strong arguments for longer periods, and really, I think 72 hours here is a compromise. I think that there are those on this committee and in the legislature who would advocate for a longer waiting period. And I think that, longer waiting periods are supported by the data as addressing the goals that you're, trying to get at. But this is a compromise, recognizing that there are concerns about it. So,
Mr. Clark, I'm curious about any thoughts on the purpose of the bill, that particular section. Does it help or hurt, or doesn't it matter in terms of litigation?
Yeah, no, in terms of litigation, it's a very good question. And it's something that's a little open in the courts right now. There are some courts that really look to the legislative findings to determine what support there is for the bill. Like even in the historical analysis, some courts have wanted there to be, historical bills in the record. Hence why I'm, happy to submit those bills that I submit to House Judiciary to you all as well. My general view is that most courts do not take that view, and that legislative findings, while helpful of demonstrating a purpose, are not necessary and can at times limit the import. I heard a little bit of the discussion this morning where, I do think this bill is addressing more than suicide. There are gains that are made from, waiting periods, and that get at other things like straw purchases and things like that. And so I am of the view that that in particular, because a lot of these studies can be, the new evidence can be coming in. You don't want to be totally bound by that. I would say that legislative findings are generally not as helpful, and not something that, if I were in a litigation posture, I would totally rely on. They do help in interpreting the scope of the law, but when it comes to defending the constitutionality, oftentimes, in particular in this post-Bruin world, we're going to be building that record out with things that may not have appeared in the legislative findings. And you can face a concern that a court will limit you to what you placed in the legislative findings.
Thank you. Very helpful. As someone who would prefer to get rid of the findings.
I do want to touch very briefly on the extreme risk protective order section, which I know we haven't discussed as much. I do think that part of the analysis there, from a constitutional perspective, we need to recognize that a challenge being brought there is less a Second Amendment challenge and more of a procedural due process challenge. For the lawyers in the room, sort of the Matthews v. Eldridge, balancing test. Like, this actually is a balancing test question where, you look at the private interest that's affected by the official action, the risk of erroneous deprivation, and then the government's interest in having this process in place. And so, as you're considering this, I think taking a pure historical approach actually doesn't really frame what the legal analysis would be for the ERPO expansion. And I think it's important to recognize the government's interest in allowing people to, seek help. I understand that there are concerns about the practicalities, and that, have our state's attorneys declining, this and all those sort of things. In my view, yes, people have a fundamental right to own a firearm, but people also have a fundamental right to petition their government for help. And they have a fundamental right to live safely in their home. And that's something that they should be able to seek redress from directly from a court. They should be able to do that. And I understand there are many other, there are other possible ways to do that in place, but the ERPO expansion to me just strikes as a fundamentally important thing for those people who, might find, who need to seek help, who need to find help, and to have them be able to go straight to the court in that way, I think is an important addition to the bill, and one that would withstand constitutional scrutiny.
Just for the record, I was the person who sponsored the original bill, and worked with some community members in Bennington, as well as Eric. And we introduced the bill in January. It passed along with several other bills, but that bill passed either 178 or 176 to nothing. There were no votes in the Vermont Senate or House. And I don't remember how many House members were absent that day. I am proud to have been the sponsor of that bill, and I don't have a problem. The only problem with the House version is the requirement that it be by a preponderance of the evidence rather than clear and convincing for the family member to go to court. I worry that a preponderance is too low a standard when it's just the family member and the judge making the decision. So that's my only concern with that version. I have absolute support for extreme risk protection orders. They've helped in a number of cases in Vermont. I'd like to hear maybe your reaction to that.
No, I really appreciate that focus of the issue, Senator Sears. So to be clear, and because it's not something I had focused on previously, my understanding is that
The fire alarm doesn't mean anything.
Okay.